So until now, we've basically gone in chronological order in the conference, but now we're going to take a step backwards in time. But a lot of the topics I'll be discussing came up in either an interest paper as well, particularly questions of forum shopping, of choice of law, etc. So I did neither. Ron talked about two cultures. I did not pre-circulate a paper, and also not going to read a paper. These are thoughts that I've had. Basically, I've been doing research on water law in the British Empire, and I've come across these issues in doing my research and the conference. So I want to thank also the conference organizers for getting me to think about these issues from a slightly different angle than what I've been doing. I think that's one of the good things that conferences can do. So I'm going to talk about overlapping jurisdictions in the British Empire. And just to preview the end, the situation in the British Empire, I think in some respects looks very similar to the way we think today, at least in the common law world, about private international law working. So we'll see a lot of the mechanisms in the British Empire, which were not supposed to work according to private international law in the usual story, come out looking very similar. So let's see what I'm talking about. The usual view about law in the British Empire is that, and it's well known that there were overlapping jurisdictions, overlapping substantive laws and pluralism with regard to religious law and tribal law, etc. We've talked a little bit about that already in this conference. So we had multiple legal systems existing in the same social space because of those issues, and I'm not going to talk about those today. What I'm going to talk about is the sort of legal pluralism which was created in the massive expansion of the British Empire from the Treaty of Utrecht, more or less, in the early 18th century until after the Napoleonic Wars. So you have the British Empire swallowing up a tremendous amount of territory in which pre-existing legal systems existed that the British recognized. Right? The British did not recognize the legal system of Native Americans, for instance. They considered them to have no law, so they just imported British law. But when the British took over Quebec, or when the British took over Cape Colony or parts of India or the Ottoman Empire, they considered those places to have pre-existing law, and they did not immediately change the law in those places. They accepted the law as it was at that time. So we had French civil law in parts of Canada, with Roman Dutch law in Cape Colony and Ceylon and today British Guiana, and so on. And to see how that differs from the application of foreign law by a court, let's say, or in a country. So let's just first of all compare two cases. So imagine in 1800, two sales take place, and they both lined up in British court. One sale is between people in Paris, and one is between people in Montreal. So in both cases, we might say that French law applies. It applies in the case of the sale in Paris, even if it's in a British court, right? So French law applies because let's say it's the law of the sale, the law of the contract. In Montreal, French law might apply, but it's a different French law. It's not the French law as French law. It's French law as the law of Canada, British Canada, to the extent that British Canada incorporated the pre-existing French law, which it did to a large extent when it came to civil law. Now, if we move the date forward to 1810, things get weirder because now the sale in Paris coming to British court will be determined by the Napoleonic Code, which is the law of the sale. Whereas a sale in 1810 in Montreal is now determined by the old French law, the custom of Paris, which applied in Quebec. And the Code Napoleon has nothing to say about this sale. So French law applies in both cases, but two different French laws. And the French law that applies in the Canadian case is actually an Anglo-French law. So we've heard about Anglo-Mohammedan law, for instance, or Anglo-Hindu law. So there's also an Anglo-French law, an Anglo-Roman Dutch law, etc. And you have this weird situation then taking place not only in Quebec, but also in places where Roman Dutch law continued to apply pretty much only in British colonies, not in the Netherlands. After the French Revolution, Roman Dutch law was replaced by French-style civil law. And you have it taking place also in former Ottoman lands. So in Palestine, for instance, in Cyprus and other places, the Majella continues to apply, which is the Ottoman Civil Code, even after it's abolished in Turkey. And again, the anglicized versions of these laws. So that's the way things are supposed to have worked. But maybe that's not exactly how it works. And I want to talk about three issues. One, how courts determined what the law was when they had to deal with these foreign systems of law that weren't exactly foreign, because they were the law of the land. Second issue is to what extent these former foreign countries that are now part of the British Empire really unmoored themselves and disconnected from their old legal system, to what extent they remain connected in some way. And the third issue is the issue of forum shopping. To what extent this kind of reality allowed people to forum shop and how they forum shop. So first, how was law determined by the courts? So normally, unlike the cases that Uri talked about yesterday, where the parties have to prove the law to the judge, so normally judges are expected to know the law of their jurisdiction, and parties' counsel can obviously help them, but judges are responsible ultimately to say what the law is. That's what jurisdiction means. Right? It says the judges say what the law is, even if the parties don't help them out well. On the other hand, according to private international law rules in the common law world, foreign law is a matter of fact which parties have to prove with witnesses, and they have to testify as to the applicable law. So in courts in the British Empire need to rule on the law of Canada or South Africa or Cyprus or Bombay or wherever, they're expected to know the French or Roman Dutch or Ottoman or Mughal law. And then normally, in lower courts, that might not be a problem because advocates and judges are trained in their local system, and pretty quickly after British conquest, they come to learn the local law, even if they came over from England. But what about the Judicial Council of the Judicial Committee of the Privy Council, which is a court that you may have. Did you show them the exhibit downstairs? In the library, there's an exhibit, right? So there's this British Imperial Court, and these judges sitting in London are expected to rule on cases, and they do. If you open the reports, it's quite amazing. They rule on, one case is on French law, one case is on Dutch law, one case is on Islamic law, and so on. So how do they know about the laws that they're supposed to be ruling on? So an 1873 treatise on the Privy Council says as follows: the Privy Council takes upon itself the functions which belong to the court whose decision it reviews. It does not inform itself on the subject of the law prevailing in any colony, as tribunals are wont to do on the subject of laws prevailing in foreign countries by taking evidence. So in other words, a court, Privy Council, just like the lower courts, is expected to know the law that applies in the case. It's not supposed to take evidence on the law. But how could they actually know all the systems of law? And it's actually more of a puzzle given the fact that exceptionally for the common law world, the Privy Council practice did not include the practice of submission of briefs. So lawyers made oral arguments, but they did not submit written briefs to the Privy Council. So they couldn't even inform the judges of the law that way. So how did judges learn what the French or the Roman Dutch law was? So one way is, A, a lot of these judges were very well educated. B, they relied on the lower court records and judgments, which did come up to them, so they could see the discussion of the law in the lower court judgments. At a later point in the 19th century, they started also appointing judges to the Privy Council who came from the colonies. So they appointed Indian judges and Canadian judges and so on to help them out with these cases. But there also are exceptional cases, which I'm going to tell you about a few of these cases right now. So in 1828, there's a case called Frios versus the heirs of Forbes. It's reported in Knapp's reports, not as a regular case. Like there's one case. He's a reporter who reported Privy Council cases. So normally, if you know what a common law case report looks like, just one case after another with a title and a date. This case appears differently. It says note at the beginning of the case. So I think it indicates it was an unusual case that the reporter picked out for some special attention. And what happened in this case, this is an appeal from colony of Demerara, which is in today's British Guiana. The law that applies there.
British
Guiana, so now it's just Suriname. Sorry. No, Suriname is Dutch. No, British Guiana there is. It's just called Guyana.
Guyana is independent. Is Guyana. British Guiana is a different place. You're talking about
South America.
No, South America. In South America.
In South America, it's independent since 1960.
He knows because he comes from there, no?
Exactly.
Really?
Yeah, it's a family connection.
We'll talk about that later. Okay, so what's it called today? Just Guyana? Just Guyana, okay. So in Guyana, which was formerly Dutch, so the Roman Dutch law applied there. And this case involved, it was a complicated case of an executor of a state who died. And the case involved a decree of perpetuum silentium, which the court gave against non-appearing creditors of the estate. We won't get into the details. Now, the judges of the Privy Council apparently did not know what the effect of a decree of perpetuum silentium meant, and so, and a quote from the report, on the hearing of this appeal before the Privy Council, it was ordered that the printed cases of both appellant and respondent should be sent to Dr. C.M. Van Hall at Amsterdam for his opinion on these two questions. First, whether after the decree of perpetuum silentium it was competent by the respondent, by the law of Holland, and under the special circumstances of the case to institute the proceedings, etc. And second, whether the court ruled correctly according to the law of Holland. And the Privy Council received Dr. Van Hall's opinion and ruled in accordance with the opinion. And again, this is weird because, so Dr. Van Hall in 1827 in Amsterdam is telling the British court about Roman Dutch law, which no longer applies in Amsterdam itself. Case number 2 is later, 1854, also this time an appeal from British Guiana, and a case of a husband who sues his wife's lover for adultery and in a civil suit. And the court, the Privy Council, again, the arguments make a lot of arguments, counsel make a lot of arguments from Roman Dutch sources. The Privy Council says, we don't really understand all these sources, but we have an English translation of Grotius, and we believe that to state the law, so they rule according to the verse, but they also say at the end of the report, this time Moore is the reporter, at the end of the report, there's a note that says as follows: the editor has been favored by the registrar of the Judicial Committee with the following memorandum of the opinion of the Minister of Justice of His Majesty the King of the Netherlands, relative to the question whether, according to the Old Dutch law, an action of damages can be brought in that country by a husband in a case of adultery. And the Minister of Justice says, yes, it can. So again, someone here is writing to the Minister of Justice of the Netherlands and asking what's the law. And here you have the Minister of Justice giving an opinion, again, about law which has not been enforced in the Netherlands itself for 50 years. Okay, that's and case number 3 is about from the Isle of Man in 1838. And Baron Park here says, who's the judge, he said, there appears to be no statute or written treatise of the law of the island in which the liability of executors and administrators is laid down, but from the information of which we have availed ourselves of the clerk of the rolls of the island. So that, and it actually says they actually stopped the court proceedings because they said, we don't know what the law is. They wrote to the clerk of the rolls of the Isle of Man to ask him to send judgments and precedents so they could understand what the law was, and then they go ahead and rule on the case. So that's one way, another way of figuring out the law. The case I want to focus on, which I've gotten very excited about, I just discovered it this week in preparing for this conference, is a 1775 case from the Court of King's Bench called Mostyn versus Fabregas. And this deals with a resident of Minorca, which was at the time a British colony, who led a rebellion apparently. The governor kicked him out of Minorca, had him deported to Spain. So Spanish law should have applied in Minorca. And Fabregas was kicked out. He sued in the Court of Common Pleas in London. He sued the governor for £10,000. And he won a £3,000 judgment in the Court of Common Pleas, quite a lot of money. And so he appealed to the governor, who was actually, it turns out, is not actually, never was in Minorca. The governor is a senator. He just sits in London and gets paid to govern. And he was a member of Parliament. So he appeals to the King's Bench, and so it makes a lot of arguments. So first he has a policy argument. He says, the court says, it is objected by the defendant, the governor, supposing the defendant to have acted as the Spanish governor was empowered to do before, how is it to be known here that by the laws and constitution of Spain he was authorized so to act? So in other words, he's saying, British court, you can't rule on the question of Spanish law. You don't know anything about Spanish law. Mansfield, Lord Mansfield is the head of the King's Bench, Chief Justice of the King's Bench, says as follows: the way of knowing foreign laws is by admitting them to be proved as facts, and the court must assist the jury in ascertaining what the law is. For instance, if there's a French settlement, the construction of which depends upon the custom of Paris, witnesses must be received to explain what the custom is, as evidence is received of customs in respective trade. So in the supreme resort before the King and Council, the Privy Council determines all cases that arise in the plantations, in Gibraltar or in Minorca, in Jersey or Guernsey, and they inform themselves by having the law stated to them. So Mansfield says about the Privy Council, which he knows something about as well, he says the Privy Council takes testimony about the laws from all these different colonies, just the same way that they take testimony about French law when a case arises from France. So it's a matter of evidence. And he says that this is the practice in the Privy Council. Now this is controversial. So in a later Privy Council case in 1841, much later, they say, well, maybe Mansfield was reported wrong. Maybe they didn't quote him right. Maybe he didn't really mean that. But we know he did, because I found another report of this case, and he did say this. So there seems to have been an early practice in the Privy Council where the law that applied in the British Empire was testified to as a matter of fact. So that's the first issue. So we have a situation that looks like a normal conflict of law situation, despite the fact that it's happening within the jurisdiction. The second issue is to what extent the legal systems remain connected to their old parent legal systems. So to take the French Canada case, so they're supposed to have completely disconnected. Once the British conquer Canada from the French, it's supposed to disconnect. The French civil law as it applies remains in force, but at that point it stops following further developments in France. However, so for one thing, we know that lawyers trained in the French tradition and continue to be trained in the French tradition to a large extent in Quebec, they retain a connection to France, a cultural connection, an educational connection. So French law continues to influence them, judges as well. And one opinion, to give you an example, so in an 1860 case, so we're talking almost 100 years after the conquest, or exactly 100 years after the conquest of Quebec from the French. So it's a case dealing with where the applicable law is the custom of Paris. That's still the law in Quebec. But the judge cites the Napoleonic Code. He cites Touillet's commentary on the Napoleonic Code to understand what the applicable law is. So even though formally there's absolutely no application of the Napoleonic Code in Quebec,
To interpret the custom?
it's not clear. It's to interpret what the law is. I mean, I think they thought about the law differently than we thought about it today. So they didn't think about it in a less positivist way than we think about it today. But so for him, these sources, which are from later French law, are relevant to understanding the earlier French law. And then, of course, also the Quebec Civil Code of 1866, as well as other civil codes in similar kind of colonies, are based on the French model. So even though they've disconnected formally from France, they continue to follow French models in adjudication as well as in legislation. So there remains some connection. It's not as simple as saying they disconnected from their parent country. And then the final issue I want to talk about is forum shopping. Now there are, in all these countries, in all these territories of so-called mixed systems of common and civil law, there are not separate courts. So you can't, if you can't go to if you live in Cape Town, you can't say, well, if I'll choose between the common law court and the Roman Dutch court. There's one court, and it applies the common law or Roman Dutch law, depending on the rules in that jurisdiction for when each system of law applies. But you can move around to shop. So we know, and that's easier within the empire than in general. So for instance, we know that slavery, that people took advantage of different laws about slavery to keep slaves, to get free, for slaves to get free when they moved around the British Atlantic, because the laws were different in different places. And then you have other examples where the laws are almost overlapping. So in the province, between 1841 and 1867, in the province of Canada, French law applies in the east part of the province, and common law applies in the west part of the province, but it's the same province, the same legislature. In India, the so-called presidency towns, Bombay, Madras, and Calcutta, so the common law, English law as of 1726 applies in the towns, but if you go out into the suburbs, it's a different law. There, the common law continues to evolve. So you have, if you could just move a few feet, not cross a border, even in these cases, and change the law that applied to you. And then so now I want to go back to this case of Maston and Fabregas, the Menorca case, because here I think I really like this case. You have a collision of legal pluralism on the one hand, and then another great English legal institution, the legal fiction. And what happens when these two collide? So this was obviously a big case. I'm going to quote a bit. Mansfield starts his report his judgment like this: on the 8th of June in last term, Mr. Justice Gould, who was judge on the Common Pleas, came personally into court, into the King's Bench, to acknowledge his seal affixed to a bill of exceptions in this case. In other words, the lower court realizes this is an important case. The judge comes himself into the King's Bench and says, here, I want you to rule on this appeal. And So, and this is typical English stuff, you have to pay attention to the details. This was an action of trespass brought in the Court of Common Pleas by Anthony Fabregas against John Mostyn for an assault and false imprisonment, in which the plaintiff declared that the defendant on the 1st of September in the year 1771, with force and arms, etc., now you have to pay attention, made an assault upon the said Anthony at Minorca, to wit, at London aforesaid, in the parish of St. Mary le Bow, in the ward of Cheap. So notice he said, I was assaulted and falsely imprisoned in Minorca, in the parish, in London, in the parish of St. Mary le Bow, in the ward of Cheap. In other words, Minorca is in London. Now why does he say that? Right, so this is a legal fiction, because this is to give jurisdiction to the English common law court. Because it's not clear that the Court of Common Pleas has jurisdiction over a case in Minorca. Normally it wouldn't. So you have, but there had evolved this practice in English law in general to give different courts jurisdiction. You made claims about where things happened that were patently false, right? Like this. So he says in Minorca, to wit, in London, and he says, you know, and then he was falsely imprisoned and assaulted. So the defendant, the governor. So first of all, he makes an interesting comment about overlapping jurisdictions. He says, the Minorcans are in general governed by the Spanish laws, but when it serves their purpose, plead the English laws. Now, why did Fabregas go to London to court? Why didn't he go to court in Minorca? Because it turns out, it's always dicey to sue the governor, but in the specific district of Minorca that he lived in, courts had no regular courts had no jurisdiction without the governor's approval. It was a sort of military rule of this part of Minorca. So he had no chance to sue the governor in Minorca. So Mansfield says as follows: in every plea to the jurisdiction, you must state another jurisdiction. In other words, if you want to say that the court does not have jurisdiction, you have to say which court does have jurisdiction. Therefore, if an action is brought here for a matter arising in Wales, to bar the remedy sought in this court, you must show the jurisdiction of the Court of Wales. And in every case, to repel the jurisdiction of the King's Court, you must show a more proper and more sufficient jurisdiction. For if there is no other mode of trial, that alone will give the King's Courts a jurisdiction. So Matt has a very expansive view here, on the one, well, expansive and limited. He says, we will take jurisdiction over any case where there's no other jurisdiction. So actually the governor here harmed himself, right? By not letting this case go forward, he's actually creating jurisdiction now for the English court. Now about the legal fiction. So the governor, the defendant, says as follows: the cases where the courts of Westminster have taken cognizance of transaction arising abroad seem to be wholly on contracts, where the law of the foreign country have agreed with the laws of England and between English subjects. And even there it is done by legal fiction, namely by supposing under a videlicet, which is this clause where you say to wit in St. Mary le Bow, London, so that the cause of action did arise within this country and that the place abroad lay either in London or in Islington. Islington is if you wanted it to go to say that it was in Middlesex, because then the King's Bench had jurisdiction. But where it appears upon the face of the record that the cause of action did arise in foreign parts, there it doesn't help that the court has no jurisdiction. You can only do this trick of legal fiction if you don't need to really say that it happened in another place, in another country. So he brings a case from India, a precedent from India, assault and false imprisonment on the plaintiff at Fort St. George, which is Madras, or Chennai, in the East Indies, in parts beyond the seas, viz. At London, in the parish of St. Mary le Bow and Ward of Cheap. So in that case, he says, the court said you can't do that. You can't say you were assaulted in Madras and Fort St. George and say that it happened in London. Because here the location is part of the facts that have to be pleaded in the case. It's different than the case of contract. The case of contract doesn't matter where the contract happened. So you could say it happened in Paris, which is in London. But when you're talking about an assault or false imprisonment, and the place that it happened is important to the facts of the case, you can't say that it happened in London. That's what the defendant claims. But Mansfield rejects this and says, if the true date or description of the bond is not stated, it is a variance. In other words, if you lie, or if you say the wrong facts on your claim and you don't give the right date or the right place where something happened, normally that's enough to have the case dismissed. But the law has in that case invented a fiction and has said, the party shall first set out the description truly, and then give a venue only for form, and for the sake of trial by videlicet in the country of Middlesex or any other county. But no judge ever thought that when the declaration said in Fort St. George, viz. In Cheapside, that the plaintiff meant it was in Cheapside. It was a fiction of form. Every country has its forms, which are invented for the furtherance of justice, and it is a certain rule that a fiction of law shall never be contradicted so as to defeat the end for which it was invented, right? So he's saying that we know, everyone knows this is a fiction, don't be stupid. So, right, this is obviously a fiction. The fiction is created to give jurisdiction to the court. So the fact that facts contradict this fiction is really not interesting to everyone, right? So, okay, so yeah, this is, I really like this case, but
Access to justice.
so to conclude, so again, the normal story is we have mixed jurisdictions, but there's stable mixed jurisdictions in a hierarchical system. But the picture I've tried to present here in these three issues is actually that we do have overlapping normative orders and overlapping jurisdictions. So even though these former French and Dutch colonies are supposed to have disconnected from their parent countries, we see that they still have connections. So the French law, Dutch law, even as they evolve, continue to affect the law in these countries. And then the second point is that we live in a world today which is very much like this British Empire world. So we live in a world today where you can move around fairly easily and jurisdiction shop, forum shop, even without an empire. And foreign legal systems influence domestic legal discourses in a very similar way to what we saw in these cases. So even if they don't do it formally, but yet we know that courts, at least in our legal culture, in Israel, as well as in some other parts of the world, so courts will look at, they won't maybe not write a letter to Dr. Van Hall in Amsterdam, but they are very much interested in what's happening in these other countries. And to some extent, the law in other countries turns into the law of the local jurisdiction through these, sometimes through adjudication. So it may just be right to conceptualize. Well, my point is just, well, I guess my point is just that this imperial system of overlapping jurisdictions and what we know today about overlapping jurisdictions through private international law are actually quite similar. I'm not sure you can actually distinguish between the middle. So that's the end.